Aloha and good afternoon. Welcome to our Hawaii Invasive Species Awareness Month presentation. Today, our presenter will be Andrew Porter from the Coordinating Group on Alien Pest Species, or CGAPS. He is the Aquatic Invasive Species Legal Fellow. Today, he will be talking about VIDA, the evolving paradigm for regulating shipborne vectors of aquatic invasive species in Hawaii. Okay, Drew.
All right. Thank you, Amber. Um, yes, so as Amber said, I am Andrew Porter, the Aquatic Invasive Species Legal Fellow for CGAPS. I work closely with DAR, and I work mostly on aquatic invasive species issues with the shipping industry, but I do much more as well. And today, today our presentation gives an overview of the current regulatory framework for incidental discharges from commercial vessels related to aquatic invasive species. First, we will look at the federal statutory framework under the Vessel Incidental Discharge Act of 2018, commonly known as VIDA, and that's how we'll be referring to it from here on out. Second, we will look at the federal regulatory framework under the EPA and US Coast Guard that was developed under the statutory framework of VIDA. And finally, we will look at regulatory changes that are suggested for Hawaii to work within the federal authorities to protect state waters. So what is VIDA? VIDA is a reorganization of 312 of the Clean Water Act that regulates discharges incidental to the normal operations of a vessel. On December 4th, 2018, it was signed by the president and became law. VIDA will preempt states from enacting or enforcing regulations related to incidental discharges, and it aims for a nationwide, or in the case of ballast water, regional-wide standards. There we go. So VIDA does allow for states to co-enforce federal regulations and act and enforce state regulations that are equal to or less stringent than the federal standards. And unlike other areas of the Clean Water Act, VIDA acts as a ceiling instead of a floor. So under most of the Clean Water Act, it really says, okay, the federal regulation is the minimum the state can have. So the state can have regulations as stringent as they want to. And that's how vessel incidental discharges were regulated underneath the vessel general permit. VIDA flips that around completely and says, okay, the federal regulations are as stringent as any state can possibly have. States can have regulations, but they can't be more stringent than the federal regulations. So it really flips everything right on its head. Regulations developed under VIDA do not come into full force and effect until the US Coast Guard regulations are finalized and implemented. And that's looking to be late 2026. Maybe with the shutdown, it's going to push over into 2027. We're just not sure yet. So until VIDA comes into full force and effect, the 2013 Vessel General Permit will continue to control the regulation of incidental discharges. One of my least favorite parts of VIDA is that it prohibits states from assessing a fee related to any incidental discharge unless that state had in place such a fee prior to December 4th, 2018. So this means that we can't institute a fee on vessels to really fund our vessel inspection program or our ballast water testing program. That money has to come from somewhere else. So incidental discharges, this is pretty fundamental to the entire thing. What are incidental discharges? So one of the key ones is ballast water, hull husbandry effluent. This is also known as in-water cleaning. There's a whole bunch of other ones, dust, bilge water, but today we're really going to be focusing on the incidental discharges that have the potential to be a vector for the spread of aquatic invasive species. So this is mostly focusing on ballast water, biofouling, and in-water cleaning. So first we'll look at ballast water. What is ballast water? So when a vessel is designed, it's designed with basically a central point of buoyancy. So, that keeps the boat stable. So if you're a cargo vessel and you're loading cargo on, then the vessel gets heavier and heavier and heavier. If it gets too heavy, it can sink. But if you're unloading cargo, then it can get lighter and lighter and lighter. And then if the center of gravity is too high, then the vessel can roll over. So how do you really keep this from happening is that if you look at number one here, so when you're discharging cargo and the vessel is getting lighter, you're loading on ballast water, hundreds of thousands of gallons of ballast water. And with this ballast water can come all sorts of planktons and protozoa and just all sorts of critters, basically in their larval stages. And so, that vessel then holds that ballast water to keep the vessel stability, and goes to another port. It could be on the other side of the world. And then when they start loading cargo on the other side of the world, well, now the vessel's getting heavier and heavier. And so it doesn't sink. They need to discharge all that ballast water that they brought on. And as you can see, this will be a problem if there's a lot of species in that ballast water, even if they're little cakey, they can grow into much bigger crabs. They can grow into, whatever it is, barnacles, any kind of aquatic invasive species. So, you can see how this would be a major vector for the spread of aquatic invasive species around the world. Biofouling is another issue, and biofouling is, as seen in the picture, just basically that gunk that grows on the bottom of a boat anytime it's in the water, and it can actually happen pretty fast. Other than invasive species, there's also other issues with biofouling. It can cause hull corrosion. There are safety issues such as if you have a raw water intake for your engine and it gets clogged up with biofouling, well, your engine's not getting cooling water anymore. And so then your engine overheats and then you have no steerage anymore. That's clearly a safety issue. And also maneuverability and fuel consumption. So, a sleek vessel hull is going to move through the water nice and exactly as it was designed. But if you have all sorts of biofouling on the bottom of the vessel, it's going to create a lot of drag and you're going to have to use a lot more fuel to get up to speed and to stay at that speed. So fuel consumption also becomes a major issue with biofouling. So for the shipping industry, it's not just aquatic invasive species issues. There are myriad issues that can come from having too much biofouling on your vessel. So what do you do about biofouling? Well, there's in-water vessel hull cleaning. And this is when you have a contraption and a device that attaches to the hull, and it can either be driven by humans or it can be autonomous, such as a remotely operated vehicle. And so there's actually two types of these units. They can either be in-water cleaning with capture or in-water cleaning without capture. So in the top picture here, you can see that if there is no capture, this is just releasing all of the organisms attached to the hull straight into the water column where they can reproduce in the new water column wherever they are. So on the bottom picture shows in-water cleaning with capture. It has hoses attached to it. So as the in-water cleaning unit scrubs the hull and the brushes are going round and round, it brings water through and captures all of the organisms that come off of the hull, and it goes through a filter. The filter is either on a dock or either on another boat, and then it goes through a filter and clean water comes out the end. And so it really lowers the risk of the spread of aquatic invasive species. So back to VIDA statutory language, what's the scope? Like, what are we looking at here? What does this cover? So VIDA covers all commercial vessels except for commercial vessels under 79 feet, and all fishing vessels are exempt from both federal and state regulation of incidental discharges other than ballast water. So this can be kind of an issue if you have a fishing vessel coming from anywhere in the world and they have a lot of biofouling on the bottom of their vessel. They can come into Honolulu Harbor, clean the bottom of the vessel, and there's nothing the state or federal agents can do about it. It's completely legal. So this is a major loophole in VIDA. VIDA does not cover recreational vessels. That's good. The state can still cover recreational vessels. VIDA does not cover vessels under the Department of Defense. This is pretty obvious. No military, the state can't regulate military. And federally protected waters are not covered under VIDA and may set their own regulations and prohibitions. So Papanau Mokuakea can set their own regulations. They can say no ballast water discharge at all. And if you go up to the sanctuary, then you have to have a completely clean hull, zero biofouling, and it has to be checked before you go up there. So that's another good part of VIDA. Still looking at the statutory language of VIDA. At the EPA discharge standards. So the EPA was given 2 years to develop standards of performance for marine pollution control devices for each type of incidental discharge. U.S. Coast Guard must concur with the EPA standards. The EPA must develop a process to consult with the governors of interested states. The EPA must focus on developing numeric standards. Best management practices are only to be used if numeric standards are infeasible for a particular discharge. There's an anti-backsliding statute that says the development of new standards must be at least as stringent as the current VGP, which would be the 2013 Vessel General Permit. And the standards would be reviewed every 5 years. So this is pretty important. If technology progresses and the state can prove that, we can meet a stronger discharge standard, then we can apply for that. And so really need to stay on top of it, and every 5 years, really review everything and try and get the standards as stringent as we can. After that, Section 5 covers the U.S. Coast Guard implementation, compliance, and enforcement, which really gets boiled down into enforcement. So the U.S. Coast Guard must pass regulations for enforcement within 2 years after the date on which the EPA passes its standards of performance. And again, these must be at least as stringent as the current VGP. U.S. Coast Guard must coordinate with the states in developing implementation and co-enforcement programs. And regulations must focus on approval of marine pollution control devices. Finally, ballast water. This is one of the ones that really drove the whole development of VIDA that people are most scared of. So a vessel is deemed in compliance with the standard of performance as long as it has an approved ballast water management system that has been properly maintained, is maintained and used within manufacturer specifications, continues to meet the discharge standard applicable at the time the system was installed, has a valid approval certification from the Secretary. So basically, U.S. Coast Guard has approved it. And another big one is that empty ballast tanks must be flushed 200 miles out for international arrivals or 50 miles for voyages within the United States exclusive economic zone. So we actually, in the development of VIDA, were able to work with our congressional delegation. And because, Hawaii's unique situation as an archipelago, we were worried about the inner island movement of aquatic invasive species. So whatever we have on Oahu, can we keep it out of Kauai or Maui or Big Island? So what they came up with is that vessels traveling between counties in the state of Hawaii or that transit outside of state waters must conduct a ballast water exchange in waters that are more than 10 nautical miles from shore and at least 200 meters deep. And, of course, if you have a ballast water management system, then you're exempt from this. And another one is that if you have sealed tanks, that's kind of a big one. And the inter-island industry in Hawaii has been really good about developing barges and tugs with sealed tanks. So instead of bringing on ballast water or discharging ballast water, they just move it around the vessel for stability. And that is the safest you could possibly have. So we definitely thank industry for really taking a step forward and working on that. So VIDA, we're still in statutory VIDA. VIDA does provide authority for state regulations. State laws regulating incidental discharges are preempted, which means, if the state has a regulation and the federal has a regulation, then federal regulation takes precedent and, the state law has no force in effect. So when the Coast Guard regulations are finalized, this preemption will take effect unless the state regulations are identical to or less stringent than the federal regulations. or compliance with the federal regulations will be achieved concurrently and complying with the state requirements. State is also allowed to enforce. So the U.S. Coast Guard is required to coordinate with the states in developing a state enforcement and co-enforcement strategy for incidental discharges. The state may bring an enforcement action for any regulation promulgated under VIDA in federal district court. But, and this, we'll get into this a little bit more later, if a state has identical regulations to federal regulations, administrative action or state court proceedings may be available. And again, we'll talk about that later, but it's a pretty big issue. And there is no limit on state inspection authority to monitor compliance of federal standards or identical state standards. So that is the VIDA statutory language. So that's kind of really controls what the underlying agencies can do and guides the agencies when they pass their regulations. So the regulations from the EPA and the Coast Guard kind of fill out the broader structure of what VIDA is supposed to say. And as I said, the EPA had 2 years to promulgate their regulations, and the Coast Guard had 2 years to promulgate their regulations after the EPA was done. The EPA actually took 5 years, but they finished up about a year and a half ago. And so now the Coast Guard's working on their regulations. So under the EPA, their ballast water regulations, they're pretty lengthy. And so we could do 2 full hours just on ballast water regulations alone. And there's all sorts of caveats, but in general, all ballast water discharge must be treated by a U.S. Coast Guard approved ballast water management system and meet the ballast water discharge standards. The ballast water discharge standards under the EPA regulations are the same as the standards under the United Nations International Maritime Organization, and that's known as the D2 standard. And these standards are based on post-treatment concentrations of living organisms and harmful indicator microbes. And I put in here that the IMO actually uses the term viable. So it's the same numerical standards, but the US uses living and IMO uses viable, which is actually, even though it's just one word difference, it makes a huge difference, because if you're using the living standard, then you're saying, okay, you have this concentration of water, you can only have 10 living organisms in it. Under the IMO standard, you're looking at a concentration of water and you can have tons of living organisms in there. As long as only 10 of them can reproduce, then you're good. And the US's argument for being different from the rest of the world on this is that it's almost impossible to test for viability of organisms, especially if you're looking at, microorganisms. So, I mean, it's a decent argument, but the VIDA does have a section where it says the US can move to the viability standard once it's proven that testing for the viability of organisms is possible and plausible. And so we're not there yet. The US Coast Guard and the EPA are still looking at that. They're looking at papers, they're looking at ways to test for this. But for now, we are still a little bit different from the rest of the world, which does cause a problem a bit if, we're developing ballast water management systems on the living/dead scale, and the rest of the world is developing ballast water management systems on the viability scale, then the viability scale is seen as less stringent. And so it causes a conflict if those international vessels try and come into US waters and discharge ballast water. So it's a bit of an issue. Hopefully it gets resolved soon. This is an example of the D2 scale. This is obviously the IMO because it says viable. But again, it's the same numbers, just different wording. And so continuing with ballast water. So every vessel carrying ballast water must have a ballast water management plan and a logbook that the U.S. Coast Guard can review for compliance with these standards. Vessels must comply with ballasting best management practices. And these are pretty obvious. The first one is, if you're don't discharge water from the bottom of your tanks, because if you have a lot of things will settle to the bottom of the tank, and if you discharge from the bottom um, discharge valve, then you can discharge a lot more stuff than if you discharge from the top. The second one, if you're sitting in shallow water and you're using suction from really low in the water, the closer to the bottom it is, the more it's going to suck up stuff from the seafloor, which contains a lot of species. You don't want to do that. So use a higher suction valve if possible. Avoid discharge or uptake ballast water near coral reefs. I think this one's super obvious. Discharging any sort of organisms onto the coral reefs is a horrible idea. They must periodically clean ballast tanks to remove sediment, but you can't just discharge the sediment anywhere. It has to go to a municipal waste system. And you must keep fully intact their sea chest screens. And this is the intake screens where ballast water is taken up. A screen on the front prevents larger organisms from being sucked up in the ballast water. Those larger organisms can mess up the filters and the whole system. So if those are not intact and the system breaks down, then the vessel has an issue. For biofouling, so kind of like ballast water, they must have a biofouling management plan and must develop to minimize the discharge of biofouling organisms. The plan elements must prioritize procedures and strategies to prevent macrofouling, which microfouling is just like a slime layer, is generally seen by some as inert. Macrofouling is once organisms grow into something that you can actually see, like a mollusk or a clam or something like that. So, something that could be viable if it was released. And so they must minimize the potential for the introduction and spread of aquatic nuisance species. Ballast water biofouling is also regulated in the hull and niche areas section, which states that the transport of attached living organisms and passive discharge of biofouling must be minimized when traveling into U.S. waters from outside the EZ or between captain or the port zones. As you can kind of guess, with the use of the word minimized, this would be very hard to enforce because minimized is arguable and pretty subjective. So it's not as stringent as we would hope it would be. They also regulate biofouling through the use of proper maintenance of anti-fouling hull coatings. And these are basically paint on the bottom of a vessel that has certain properties that prevent organisms from growing, such as certain metallic elements or chemical elements or ablative properties, where if something starts growing on a vessel's hull, once it gets up to speed, it'll just flake off in mid-ocean waters where it can't cause any harm. And now we get to in-water cleaning, which is kind of a mixed bag of good and bad. Excuse me. So this section says that hull and niche areas must be managed to minimize biofouling, such as through preventative hull cleaning of microfouling. So this section basically allows vessel operators to clean the hull as long as it's only at the microfouling, which is the slime layer that I was describing, that is generally seen as not posing a great risk to the spread of aquatic invasive species. That's arguable. But so they can do that anytime they want, wherever they want, and there's nobody can regulate them. And it does say that hull and niche area cleanings must minimize damage to the anti-fouling coating. So don't just go in there, scrub really hard, and have paint and all the biocides going everywhere. That's clear. But again, they use the word minimize, so that's pretty hard to enforce. But what we did argue a lot about with the EPA, and we did manage to get through, was that any discharge from in-water cleaning without a capture system of the macrofouling is prohibited. So that is a huge win and very protective for the states. So in-water cleaning with capture will be allowed, but it's not really covered under VIDA because the EPA said that it is actually not covered by VIDA, but instead under the State Clean Water Act, National Pollution Discharge Elimination System permitting system. So that would actually go through the state of Hawaii. Um, uh, Department of Health would set that up. So we can still regulate the discharge from in-water cleaning with capture. U.S. Coast Guard enforcement regulations, as I said, EPA had 2 years. Now the U.S. Coast Guard is in their 2 years. They're about a year and a half through it. The U.S. Coast Guard enforcement regulations are currently under development, so they're not available to the public. So we can't really discuss them here. But we can say under the statutory language of VIDA, there are basically three options for state involvement in enforcement. One option is do nothing and just let the Coast Guard enforce their own regulations. VIDA allows for the co-enforcement of the federal regulations with the U.S. Coast Guard. So the state agents and the U.S. Coast Guard can both go out and simultaneously enforce the federal regulations. Or the state can enforce state laws or regulations that are no more stringent than the federal regulations. So that would just go through the whole state law process. So now we move into the section where, like, what can the state of Hawaii do right now to prepare for VIDA coming into full force and effect sometime in late 2026 or early 2027. So as I said earlier, state law will be preempted from enforcing any law or regulation that is more stringent than the federal law. So what we could do is pass a bill that effectively and immediately mirrors federal regulations with state regulations. And, if they get updated every 5 years, it just automatically updates to whatever the federal regulations are at that time. And this would serve multi-purposes. First of all, it would prevent confusion in the shipping industry as to what regulation exists for each enforcement authority. So if the state and the Coast Guard both come up and they're like, okay, well, what are you enforcing right now? Are you enforcing state law? Are you enforcing federal law? You can see how we don't want to confuse industry as well as ourselves. And it will also prevent confusion between federal and state enforcement agents during co-enforcement activities. So if you have a state enforcement officer and a federal officer going on to a vessel and they're working under different rules, you can see how that would get confusing. They're saying, well, this isn't violating our rules, but this is violating their rules. And, they just need to be working out of the same rules if we're going to co-enforce effectively. And the biggest thing, which I alluded to earlier, is that it would allow the state to enforce through state regulatory processes, such as administrative penalties or in state court. So for small infractions, like they forgot to send a ballast water report to the state 24 hours ahead of time, that could be an administrative penalty. So that's kind of like a speeding ticket. It's issued by DLNR and say, okay, pay this fine and you're good. Or, for bigger things, it can go through the state court process. Otherwise, any kind of infraction that the state would find, they would have to bring through federal district court if we're enforcing federal law, not state law. And there's no wiggle room there. So if they forget to send in a ballast water report and we want to send in a penalty for that, well, we would have to file a case in federal district court. And that is absolutely never going to happen because it's just not it's not big enough to have a federal case over. So there would basically be no enforcement of that on the state level. So, that's something we can look at and something we can do for the state to have enough authority and flexibility to work with industry and really make sure that both small and big infractions are able to be taken care of appropriately without going through federal district court. And that is all I have for today. If anybody has any questions, just let me know. And if you're not here today and you watch this and you see something, you can always email me at andrew.n.porter@hawaii.gov.